Thanks for everyone for joining this very experienced panel to talk about intellectual property and the challenges this morning. My name is Donna Edmonds. I'm the CEO of a biotech company named BrainBox Solutions, who are developing a system for diagnosis and prognosis in brain injury. We've got a panel of several folks that I know and would like to share their insights with you. I'd like to have them introduce themselves one at a time, alphabetically, starting with Reed Adler. Reed.
Sorry, had to unmute.
Okay.
I'm Reed Adler. I'm a partner at a small IP and technology transactions firm called Capital Technology Law Group.
Charlie?
Hi, I'm Charlie Andrus. I'm a partner at a very large law firm called Greenberg Traurig.
Okay. Laura?
Good afternoon, everybody. My name is Laura Green, and I am a partner in the Patents and Innovations Group of Wilson Sonsini in the DC office.
Kalala?
Hi, I'm Kolale Skandanian. I'm Vice President and Chief Innovation Officer at Children's National Hospital in Washington, DC.
Great, thanks for all being here. I'd like to start off with Charlie giving us an overview of boutique or big practices. As biotech firms start up, they often have choices or are working with mandated firms that their licensors have provided the direction for. So I wanted to give him a chance to talk about the different challenges working with big and small firms. Charlie?
Thanks, Donna. So Donna, this topic, regardless of how I address it, is going to be controversial. I just want to put that out there.
That was the point.
In some instances, I'm going to be painting perhaps with a broad brush. And I want to say at the outset that there are fine practitioners at all size firms. So you've got great practitioners that work at big firms, maybe smaller AmLaw 200 firms, and also boutique firms. Having said that, I think, when you are a company that's looking for a firm, and especially maybe a startup, the first question you have to ask yourself is, what is it that I want to get from that firm? And so, for example, if it's strictly kind of someone to work on patents, maybe a boutique or a big law firm would work equally well. If you're looking for kind of across the board advice, where you may need FDA advice and to map out a regulatory pathway that ultimately becomes your pathway to market, you need complex transactional support. I mean, something beyond simple licenses, like maybe, a clinical trial contract that could run 120 pages, or an MTA or an MSA. MTA is material transfer agreement. MSA is master services agreement. Corporate advice, et cetera. Then in some instances, it may make sense to go with a bigger firm because the bigger firm has all those capabilities, and typically a smaller firm may not have all of them. I would also say that it's also important to think about whether or not you're going to need help accessing capital, whether that's VCs, whether it's family offices, whether it's high net worth individuals, whether it's a private placement. And it's generally a good idea maybe to ask, to interview lawyers and ask them kind of what their Rolodex looks like in that regard, and who they can connect you to and how they might connect you, if that's a concern. So all those things kind of play into a decision. And then maybe the last thing is, are you more concerned with building a relationship with a specific lawyer, or are you more concerned with sort of having a particular firm's name on your slide deck? And so these things, also matter, and it's kind of individualized for each company. But those are some basic considerations.
Yeah. What about working collaboratively with outside boutique firms? You have a position on that? Because often hybrids relationships are the ones that work as the small company grows.
Yeah, and so I think, most firms will work collaboratively, right? It really is what you're trying to do ultimately is advance the interests of the client. And so if a collaboration is a way to do that and the client has decided, hey, this is, the best way to go, then I think, most firms will work collaboratively, because ultimately, I mean, we're here to serve clients. And so, if that's what the client needs, then that's what you do.
Kalala, you sit in a chair where you are frequently a licensor. And at least in my own experience, when you start licensing products or licensing assets from a large university, in our case, it's UCLA and Hopkins and a couple of others, they have relationships with large firms to protect their own rights. As you start working with folks, what is, and I'm not talking big firm versus little firm, what's the most important thing sitting in your chair for a long-term relationship with somebody who licenses your technology?
Yeah, thank you so much, Donna. At Children's National Hospital, we have the Office of Innovation Ventures. So it is not a traditional tech transfer office that you see in large universities, but we do provide tech transfer function to our faculty and inventors at Children's National. And I say that because, when we built this office, when I was building the team for Innovation Ventures, I was really picking experts, folks to join the team that did not come from a tech transfer background. Actually, I wanted us to embrace a mission that, we work with our licensors to jointly bring a product to market. So the perfect relationship is that type of collaboration and partnership. And our mission is really to add the D in development to the R in research. So R in research is what we understand very well. And the D in development is where we look for partnership and for collaboration. And that's when we really selectively pick the right partners to work with so we can jointly bring the much needed medical products for children to market.
And I'm going to ask Laura to comment on this. From a technical capability perspective, when it's often a physician comes and brings an idea and wants it to be, wants to take it to market, you emphasize putting the R, but you have the history of having the ability to do research, but you need development. What are you looking for on the other side of the fence from a talent and legal representation perspective? I assume you have a firm that represents your best interest at Children's that you lean on. What are you looking for on the talent side from the licensee?
From the licensee, and thank you, Donna. From the licensee, we're looking for somebody who's willing to work with us and willing to talk to us. Like Charlie said, it's all about the client. And for the licensee, we want to have somebody who's, has passion about their product and wants to get to market and is willing to talk to us. We have a lot of PhDs here at Wilson Sonsini who would understand the technology and be able to give that licensee the best application and to also cover things that may be coming up in the future. So we want a licensee who's also looking to the future and where they think they may be going. So I think that's really what we're looking for in a licensee.
And how does that fit with you, Kalala?
That fits very well. So it sounds like, we're talking about the same thing. I think that, the licensor-licensee relationship to work very well is, to have that joint passion for the product that is being brought to the market. Trust is very important, of course. Now at Children's National, we always own the IP. So even after we license it out, of course, we're still the owner of the IP. And we work with a number of law firms, depending on the technology, and we make sure that the licensee is also comfortable. Often the licensee, of course, they engage their own IP counsel, or they have their own in-house IP counsel, whether external or internal. There needs to be some alignment and good relationship between the counsels as well.
So I'm going to ask both of you, and Rita, I'm going to come to you afterwards. Here's the elephant in the room. How important is adequate proof of financing to both of you? Somebody you're allowing to take your asset that you're licensing, and from an IP attorney's perspective, making sure that the dream is actually achievable because of the financing. What do you look for there? How important is that? What kind of quality of money are you talking about? Laura, I'd ask you to comment on that, because you probably have to assess that going in as well.
Yes, we work with a lot of very small companies. I mean, we're talking about the Stanford professor who is just starting his own company. But because of that, they do have relationships with certain venture capital. And that's helpful, but it's not necessary. So what we're looking at is we're looking at the invention and looking at the plan going forward. And do they actually have a plan and have that capability of going out and talking to people and getting that capital? And, we work with the client, we start small, maybe do their one first basic application that's going to support their work and help them get that financing. But we're willing to work with somebody if they have at least thought things out and have a plan of how they're going to get financing.
Yeah. Charlie, you work with I think it's now, isn't GT like the largest firm in the world now, or close to it? Your perspectives on that, on the financing piece? And, yeah,
I think
full disclosure, GT is the firm we work with outside from Hopkins. Go ahead.
Yeah, thank you, Donna. So I think, when we look at things, right, we're looking at a number of factors. So when I'm talking to a CEO, I'm thinking in my mind, is this somebody I can put in front of a venture capitalist and look credible? I think that's really important, because you've got one of three choices. You either put the CEO in front of the VC, you either build a team around the CEO and put the team in front of the VC, or you just kind of say, maybe this isn't going to be a good fit. Yeah. I think, in terms of beyond that, right, many VCs, and I'm using VCs, but family offices and supplies generally, have their own secret sauce, but it kind of boils down to three things, right? They're going to relative weight the technology of one or a two. They're going to relative weight the market opportunity of one or a two, and they're going to relative weight the team about 1,000. And so what you're really looking at is, how credible is the team? And then once you've passed that kind of hurdle, then you kind of, at least for me, I look at other things. So Donna, I think a physician, excuse me, was raised earlier, right? One of the things I would say is that if that physician is working full-time, and that physician is supposed to be leading the company, you're going to have a very difficult time getting funded, because in general, funders look at that and say, look, a physician is busy enough to be working 2 jobs. I don't see how the physician's going to do that if they're practicing and also run and grow a company. And so, you're really looking at the whole mix of things, in deciding, and guiding the client.
Yeah. All very helpful. I appreciate that. That's kind of how you get started. Again, Reed, why don't you give us some background, and from your perspective, what the toughest issues in biotech you've had to manage through? And again, I'm Reed was involved with Craig Ventnor in the Human Genome Project, so he goes back to really deep science. Why don't you take that topic, please?
Great, thank you, Donna. So focusing really on IP issues, there were 4 things that I thought about to mention on the panel. I'll just name them and then cycle back through them. One of the challenges is acquiring a large patent portfolio. Another one has to do with what can become very complicated freedom to operate analysis, FTO analyses. There's sometimes sudden changes in management or products or staffing who I might, it might involve people I interface with regularly. And then the last of the 4 I would mention is litigation. And just to cycle through those briskly. So with acquisitions of large patent portfolios, some of the challenges include a lot of deadlines coming up and decisions that need to be made about which patent claims to pursue in which countries, when I don't necessarily know the subject matter or the prior art. And there are oftentimes license agreements involved that have certain requirements about maintaining patents or consultations. So logistically and administratively, it's a challenge separate from the legal decisions that need to get made. Another challenge also in that regard, it usually makes sense to keep the current counsel involved, both where perhaps the largest patent portfolios are, usually US, Europe, Japan, but keeping the current counsel motivated is important because most of the time in an acquisition, whoever got acquired, their patent attorney is going to assume somebody else is going to take over the work sooner than later. Freedom to operate analyses can become very complicated. There are a lot of rabbit holes that we end up sort of climbing down and exploring and aren't necessarily meaningful. And what I found is one of the biggest challenges is managing client expectations. Like I'd like clearance on this, but it may be that somebody has 30 US patent applications and the examiners in each case have been told different things. And it takes a while to get to the place of being able to say, okay, this is what the claims actually mean. This is prior art that got overcome by making limitations to the claims. A challenge with this is oftentimes freedom to operate analyses are not scheduled and you don't sort these things out in advance. The process is often driven by an imminent transaction or a financing opportunity. And so when I can, I try to work with clients to keep FTO work sort of ongoing, even sort of at a low rate in the background. What I found from management changes that I've experienced as an in-house counsel and outside counsel is that communication skills are really important, and there's usually limited time to get in front of people. And so slides that you draft and come at an issue from 2 or 3 different perspectives, but short, compelling, clear. And again, it's not so much a legal issue, but it's really more of a management and a communications kind of thing. I could probably stop here and not get into litigation, but that's extremely challenging, largely because of the budget implications and whatever time you think you have with people. If you're talking about litigation instead, it's hard to get the real work done or the day-to-day work. So I'll pause.
So for me, I feel like I'm looking in the mirror a bit as I've cycled through several, as a serial entrepreneur, several of these things. So I think that those are all worth pointing out. Does anybody else have any comments? I think it's the long-term relationship and the precision in, stepping through each of these on a regular basis that makes it important. Charlie or Laura, you want to mention anything? Or Kalala? Kalala, sitting there on your side, do you sit in on meetings with your licensors through all these processes, or do you pretty much advocate authority when you send them over? I know yours is a relatively new office, but kind of what's your dream? I also know you're a very thoughtful person. So as you're trying to develop the one that works the best for children's, do you see yourself sitting in on those, on an ongoing basis, or you just kind of check in if you're worried?
No, I do, and we do. My team does as well. It's a fairly new team. This is a fairly new office and function at Children's National, although the notion of innovation was introduced to Children's National about 10 years ago with the establishment of the Sheikh Zayed Institute for Pediatric Surgical Innovation. So it's great that, we are kind of new in the market, in terms of licensing and commercialization. And it's great because we don't have any bad habit, and so we built everything exactly as we wanted. So I do make sure to keep very good relationship and a continuous relationship with our licensees, even though we're very young, but we have a very impressive portfolio of already 20 license agreements at Children's National with our portfolio. So I think that is quite impressive, and it's growing very fast as well. Another, factor I want to mention, we felt that it was very important to have an expert in-house, a patent agent with scientific background, with life sciences background in-house. So that person we hired actually from a law firm, from a very top law firm. We hired a scientist with life sciences background and with a top law firm background. So we're very happy to have our senior licensing associate with that type of background. So that helps to really educate our faculty. So they're part of the process when we are writing claims as part of a patent application, and we work very closely with our external law firms, external counsels, to make sure that we do everything that we can to get it right, the first time. And so there are less expenses for filing continuations and, correcting some elements that should have been in place the first time. And of course, our licensees are interested in having a very solid and solid patent portfolio. So it's very important for them to also know that we're working with the best in class to make sure that, our IP strategy is on the right track.
So I sat on the Intellectual Property Foundation board for 8 years at VCU. And so I sat in your chair for a while. And one of the things we were always short on was enough talent to be doing that sort of thing. And I don't know from from the lawyer's perspective, whether that's one of the challenges, is making sure that there's enough attention or what I would say is appropriate level of involvement, not hammer, but in fact, collaboration. Is that something you face, Charlie and Laura and Reed, on a regular basis? Or, is that a tough thing for you to manage, not having the licensor have, enough resources to help?
So maybe I'll just take a shot at this. I think generally no. I think your best tech transfer offices in general recognize that they want to be partners in the translational process from bench to bedside, as it were. Mm-hmm. And there's also recognition that day to day they're not involved as much in the company, and so they're not as current on the direction that a particular company is going. And so
you mean nod my head really heavy on that one?
Yes.
Okay.
Right. So, right. There may be times when you have a discussion, like, why are the claims migrating in this direction? Because you'll see at times, like, maybe there are multiple inventions in an application. Right. The TTO initially thought that maybe one invention was sort of first among equals. But now the company is saying, actually, we want to really pursue invention number 7. Right. And so, you might have discussions about that. But generally, you're seeing the better TTOs look to partner. And not only are they looking to partner, but even at the licensing stage, they're going to give you a reasonable term sheet. Because, for example, with a university, there's a recognition that if the company does well, if it's one of those 1 out of 10 companies, and the TTO was a good partner and the university was a good partner, then maybe some of the founders might say, you know, we had a really good experience with them. We'll endow a chair, or we'll put our name on a building, or we'll do something else. And in some ways, that is more beneficial to a university, a TTO, than just say getting minimum annuals and running royalties and hitting milestones.
So I'd like to step away. I have a couple of tactical questions, and then I'd like to talk about once a company starts going, they actually do file their own IP, and it isn't necessarily always, you know, licensed in from a university. Laura, let's address the fact of, you know, how to know when to hold or fold your IP. You know, as things go along, things change, and at some point, the dollar investment in maintaining the verbiage or wherever the patent has evolved to becomes a financial and business decision. How do you know when to hold them and when to just kind of say, you know, let it go?
My background is I spent 25 years at the USPTO and then spent 17 years at the Patent Trial and Appeal Board as an administrative patent judge. So I have seen everything that can go wrong.
Right.
I also spent a lot of years doing the AIA trials. Again, that's with issued patents and also seeing where things can go wrong. So my preference is always to have a continuation going, especially if there's anything left valuable in that particular patent, because then you can always go back and amend your claims. And even if a claim, it may not just be the invalidation of a claim, it may be that you got a construction that you don't like. So you want to go back and get a claim that has the construction that you're trying to push for possible litigation in the future. So I like to always have a continuation going. And you may also have an undisclosed invention that at the time, you know, early on in the prosecution, or, you know, even later, you don't think that you need, but later on, maybe 5 years down the road, you're thinking, oh, you know, that's not a bad direction to go. And then you still have the application pending to be able to pursue that invention. You can always go after reissue, but reissue is much harder than just having the normal day-to-day prosecution in front of an examiner. And it's really not that expensive to keep a con going. So you don't have to do a lot of prosecution, just kind of keep it pending. But you really do have to look if the cost of prosecution is exceeding the business value of future patent protection, or resources are scarce. You may have to make that decision. But I would be very careful in making that decision and think it through carefully. If you just really don't have the resources, you know, you may have to abandon those particular applications that you're not really pursuing. Or on the other hand, if the patent's not that valuable anymore, you can stop paying the maintenance fees and maybe keep the con going so to a place where you may want to go later.
Yeah, I think that's very insightful. I appreciate that. So let's go through, now we've got a patent portfolio. It's growing, it's getting bigger, it's getting expensive. Sort of regular surveillance is a really important piece of managing your portfolio. Reed, why don't you go through your sort of list of what are the best tools that can be used, and who inside the company should be the one doing those, you know, doing that surveillance and using those tools.
Thanks, Donna. What's often important to do is keep an eye on competitors and other people that are filing related patent applications. And those are usually findable with a sort of a keyword search, and patent applications get filed all the time. They get granted less often than they're filed, but still all the time anyway. And there's a couple of tools that I use for different parts of sort of monitoring a patent portfolio. One of them is, I guess there's sort of two classes, the free tools and the expensive tools. And so on the expensive tool side, I use, and my firm uses, a patent analytic service called PathSnap. And there's some others like that. It's really excellent for searching and analytics. I can share workspace with clients and export lists of patents or copies of patents. And it makes it easy to find what we want to talk about, as opposed to downloading and emailing people links or downloading and emailing documents. What I like about it most of all, beyond how effective it helps me be with a client, is it saves me a lot of time. I don't have to go to different sources. There's a comparable kind of service called the Lens. It used to be Patent Lens. It's also great for searching for families, counterparts. And I use, in fact, Google Patents frequently if I just want to download a PDF quickly. PubMed is another important tool. I think I'm continually doing keyword searches that parallel what I might be looking at in patent searches. And so to your question about who should do what, I love to have clients who have a technical person or a business development person who in parallel is also looking at competitors or landscape where the company might be interested in developing a product, because they will always find things that I don't see and vice versa. I think it's really important that a company, client, university, government lab take some ownership in understanding what the landscape looks like. One other tool that I use a lot is called Patent Bots, and this is free for limited information, but it gives statistics on US patent examiners. And it doesn't mean I can't get a patent allowed with an examiner who has a low allowance rate or the converse, but it helps me manage my own expectations and my clients' expectations. So I always check this.
What's
Sorry.
that? What was
It's
the
called
name?
Patent Bots.
BOTS?
BOTS. And I've got links to these tools if the handout I'm talking from is available, or people can just send me a note at my law firm. But it is helpful because sometimes it will tell you an examiner's allowance rate, for instance, is X, but it goes to X plus 10 if you have an interview with the examiner, or X plus 20 if you file an application, take it to a final rejection, and then refile as a continuing application. So it's just a way to guide expectations. And the patent system is expensive and obscure enough to most clients anyway. And this is just a little part of helping it seem a little more predictable and manageable.
Yeah. Charlie, do you want to make any comments? Do you adhere to those, or do you have other ones you think about?
So I think they're generally good tools. One of the nice things about PatSnap is it's got a sort of a graphical three-dimensional tool. And I mean, I don't always agree with the results, but it's an interesting picture where it will lay out a sort of landscape with peaks and valleys, sort of a topological patent map, if you were, and will show you where your patents are and how close they are to other clusters of patents. I think everyone looks at, Patent Bots for examiner stats. My experience with that is mixed. I would caution that there is some utility, as Reed was saying, and for example, knowing that if you get to the point where you're at a third office action, you do an interview, maybe your odds of allowance go up. But the caution is that each case is sort of unique. And so you have to sort of weigh that information in the context of your claims and the references that are being applied against you and your previous experience with an examiner. I think the last thing is that it's probably better to get in early if the company can afford it and have an interview. It gives you the opportunity to frame the case. It gives you the opportunity to understand the examiner's thinking. And it kind of prevents both sides from digging in, because once that happens, then it's harder, in my experience, and probably the experience of everybody on this call, to move a case forward.
Yeah. So we're getting close to our time limit. There's a couple more things I wanted to cover here. Laura, do you have any comments on the tools? Because I mean, this is really important because you don't have to, if you know about the tools, you don't necessarily have to have an attorney track those kind of things. You can build your own in-house capability to, walk through these once you've got the access. Any comments?
I would never forget about the USPTO website. It has a lot of resources and everything else for inventors and different ways to search patents and things like that, and it's completely free. Another thing to think about is usually the scientists know who the other competitors in the field are. So just setting up a simple Ask Me search and following your competitors is an easy way to go. Whereas a keyword search may bring back a lot of results. Here, you're doing a more directed search to people who you know are working in the same space.
Right. I would agree. All that takes time and discipline. And, getting back to the original comment of staffing changes, building a team that, for 3 or 4 or 5 years continues to work together on this particular topic is really helpful. Losing your IP people or your scientist that tracks this is very costly to a company and something that, we need to pay attention to. I'm going to get into sort of ex-US kind of questions now. We all, at least my experience has always been US patents, US clearance, go to Europe, get your PCT and move it from there. But beyond that, I'll get to the final question is China. Do they steal or should you protect? But before we get there, I'd ask the attorneys to comment on the fact, do you go to the country or do you span Europe and Japan as being, US, Europe, Japan? How do you get below that and spend more money? When do you make the decisions on further filings individually? Laura, why don't you go ahead and then I'll ask Reed and Charlie.
I think it depends on what the product is and where it's going to be used and possibly where it's going to be made. For example, if you're thinking about going to India and using some of their vaccine facilities or different ways of making different pharmaceuticals, you may want to go ahead and have your method of making protected in India as well. So I really think it depends on where you see the product going and where you see different parts of it being done.
Good point. Reed?
One other aspect of where to file outside the US for a lot of companies includes a decision about where would a competitive product get manufactured. Right. And there are a limited number of companies. What's, I guess, fun and a huge challenge about ex-US filing is you're basically trying to be a crystal ball and figure out 10 years out if the product's approved, if it's sold in that country, will patent protection be meaningful? Is it enforceable, et cetera? And also interesting, the world's changing a bit now as we think about sort of health security in terms of who can make vaccines and such. And so there are a number of people. I have a client involved in trying to bring some sophisticated biopharmaceutical production facilities to several countries in Africa. And if you look at places where mRNA vaccine patents are filed, South Africa might be the only place in the continent. And so medical products are going to be producible within the next 20 years in a lot of places where biopharma companies haven't traditionally filed.
Correct. Charlie, any comments? And this is all very topical.
As opposed to tropical, right, Donna?
Yeah.
I would say generally you want to track, if it's a pharma or a diagnostic or a med device, you want to track to the extent that your budget can afford it. You want to track kind of the major commercial markets. So Donna, you already pointed out the US, you pointed out Europe. In Europe, there's maybe, 6, 7 countries. Beyond that, all the other factors that maybe Reed and Laura were discussing come into play. But, generally what you want to do is have a lock on those markets. And then anything else, in my opinion, is kind of a bonus for the company.
Right. Excuse me. Kalala, you're sort of at the other end of the spectrum, but is there any comments have you done any think about the direction you want to guide your folks, your licensors? Excuse me.
Yes, absolutely. And I agree with Laura that, scientists often are, or inventors are the ones that would advise the best, in terms of other territories. And, one nuance I wanted to mention is that, when we're advised to file China, Hong Kong is a different filing, right, folks? Yes. So, yeah. So that nuance is something that we always have in our mind when it's recommended to file in China, for example, to make sure that we have to also understand what does that mean, and whether it has to be Hong Kong versus China. So it's, for us, it becomes, of course, very expensive. We pay for all the patent costs, and we're also mindful of what a potential licensee may want. So it has to all balance out. And of course, our strategy, again, I want to emphasize that we are not a traditional tech transfer office. We do tech transfer functions as part of innovation ventures at Children's National. So our model is very novel, very progressive, and we do want to work with the licensees to make sure what makes most sense for licensee that is commercializing the medical product.
Okay, I'm going to go around one by one with the attorneys and ask the final question. China, yes, no, and Hong Kong, now that it's no longer as independent, yes, no. Laura?
Again, I think it depends on the same things we've already been talking about. But if you're worried about products or something being made in China, IP rights are territorial. If you don't have patent rights in China, you can't protect your patent rights in China. So, it's really a business decision.
Yeah. Are they still, I mean, I did a bunch of studying with this. Are they, even if you have IP rights filed, are they safe, or do is it your sense that it's worth the effort and they really don't steal, or yeah?
I have a lot of clients who still file in China. And because it's becoming a world market, I think China has some recognition that it has to play fair to a certain extent. So I don't think we can just say, well, they're going to steal it anyway. Let's not file there.
Topical. Charlie?
I think it's an individual decision. Generally, if you're going to go after China, I would also go after Hong Kong. The one thing I would say is that China is kind of a stickler for only allowing you to patent things you've actually done and made. Mm-hmm. So if by the time you filed, you haven't put a lot of things in a vial, China may not be an optimal jurisdiction, because the claims you're going to get are going to be so narrow in scope that you may want to think about whether it's worth spending the money.
Yeah.
And I agree with that. The only thing I would add is several of my clients are involved with licensing and partnering transactions for Asian market, for instance, and having patent in China can be helpful. Whatever it costs, whether you get a patent or not, perhaps having a stake in the ground sometimes facilitates a bigger transaction or partnership. But I agree with everything that Charlie and Laura said also.
Yeah. And if you behave as though you expect to be respected, I think it's a better, you're in a better position. At least that's been my experience in former companies. Does anybody want to add anything? I think from my perspective, this has really covered a lot of very interesting topics thoroughly, and I appreciate everybody's preparation and time for it. Laura, and do any of you want to add anything else? You want to do a wrap? Any final comments from anybody? Yes, it's important. Spend as much as you can and build your staff internally. It's kind of a summary that I come away with. Okay.
Yeah, Donna, I'd just like to thank you for organizing this, and to thank all of the folks at TaylorMade and all the folks on the call for really an excellent discussion. So thank all of you.
Appreciate it very much. Thank you. Thank you.
Thank you.
Thank you so much.